and expert witness in high conflict divorces, child custody battles, and child abuse related cases. Dean's presentation, Child Abuse and the Accused, the Law, the Science, and the Reality, will articulate the differences between consulting and testimonial experts, the impact of sexual allegations in divorce, and parental alienation syndromes, child victim hearsay, child suggestibility, and source monitoring, and forensic interviews of children allegedly abused. In his presentation, Dean will refer to two of his own live case studies. Ladies and gentlemen, please welcome Mr. Dean Tong.
I'm Dean Tong. I'm a child abuse expert, a custody expert who involves in cases with lawyers and parents accused of abuse nationwide. I'm based here locally in Tampa Bay, Florida. Today I'm speaking at a conference relative to the courts and the government on policy and child victim hearsay, basically educating the public here to what goes on in these cases, high conflict custody cases where child physical and sexual abuse allegations are made, the accused is presumed guilty, he basically has to prove a negative and his innocence to be clear. So this is kind of the opposite way of things are done in this country. And so I'll be talking about that, and my website is abuse-excuse.com. You'll see how busy of a guy I am. It's approaching 900,000 hits. The website's been up since '97, but that's obviously the population of a major U.S. city. So it's a very busy website. I'm a published author, and I've been doing this work professionally for 20 years.
First I want to thank Chris and Paul, Raquel, and Glenn for organizing this event. I want to recognize a longtime colleague and friend of mine, Dennis Siegel, in the audience here. Dennis, stand up if you would. Dennis has worked with wayward youth in the Tampa Bay area for some time, kids who wind up in problems with the law, and has actually referred a few cases to me. Terrible situation there. But as I drove up today, I noticed there's a cemetery next to us. I didn't know if that was for me or for the DCF. So maybe they know I'm here. Tomorrow, Hillary Clinton is announcing her presidency, her candidacy for presidency. For those of you who don't know Hillary, she wrote the book "It Takes a Village" 20 years ago, which is about, in loco parentis, parents patriae, the state as the parent. That's why we're here. Governmental interference into the lives of children and families, the state, Washington, D.C., the government, DCF here in Florida, they believe they're a better parent than we are. So this talk is going to be basically he said, she said, what a child said, child victim hearsay, and how just words without any physical proof can ruin your life in a New York minute. So under Florida statute 90.80323, the 23 being in parentheses, that is our 23rd exception to the hearsay rule. So when a kid tells her mommy, my daddy touched my pee-pee, and then repeats that to a CPI for DCF, child protective investigator, or CPT interviewer, or police officer, or therapist, or guardian ad litem. In Florida, we require what's called independent corroboration, which means two or more sources. So the kid has to tell two people. That could be her mother, and it could be a DCF CPI. That's it. And then, so by definition, what is hearsay? Hearsay is an out-of-court statement made for the truth of the matter asserted. Generally speaking, it's legally inadmissible. Not so here. So when a child says and implicates somebody in an abuse or neglect situation, or even a woman in an ex parte 741.30 domestic violence injunction, just based on allegations, statement of fear, threat, and bodily harm, all of a sudden that hearsay is admissible. Now the law requires the hearsay to have certain components of reliability and trustworthiness. As an expert, that's where I come in, to help the attorney, to help the accused, if it's a false allegation case. So I go over the intake reports from DCF and the police if it's a criminal case. Obviously, the forensic interview on DVD is the most important critical piece of data we have. The child's supposed to be taken here in Tampa. It's called Mary Lee's house. For those of you who are not privy to it, the website is maryleeshouse.org. MaryLees house.org. That's where they take the kids here in Hillsborough County in Tampa for the forensic interviews on DVD. Are they using best practice methodology? Sometimes they do. Most of the time they don't. They would use what I would call an acceptable practice, RATAC, R-A-T-A-C methodology. The NICHD is the #1 best practice methodology. The only state that uses that one is Washington State. So America thinks that they're doing the right thing with the kids. They're not. The government. Well-meaning, well-intentioned, but very misguided professionals, undereducated, undertrained, all the way from the DCF to the CPT to the police, to the doctors who are doing the colposcopic rape exams. 99% of the rape exams I get, within normal limits, no evidence of trauma, but consistent with the child's outcry, can neither confirm nor deny sexual abuse, cannot rule out the possibility of sexual abuse. Well, excuse me, doctor, you just did a vaginal rape exam and now you're a psychiatrist? You're opining on the cognitive aspect, the brain aspect of the child? Really? See, so I have to educate lawyers, and make no mistake, under Florida Rule of Civil Procedure 1.390, I'm considered a skilled expert witness. As such, I challenge attorneys. That's what I do. Most experts don't do that. Most experts, as Glenn pointed out, with the system, go along with the flow. I'm the guy the system loves to hate. They don't like to see me coming. They know they have to work, both the other side and our side, because I make lawyers work. By God, when I get on the case, you're going to work. You're going to roll up your sleeves and you're going to do the work. The hearsay is interesting because 95% of these cases, in child sex cases, the exams are normal. Only 5% do we see actual trauma. So that's a lot of cases we're getting under Florida statute 800.04, which is our criminal statute, our Jessica's Law, lewd and lascivious child molestation. I just got one in Tampa. My guy's in Orient Road right now. It's a state-paid case. He can't afford bail, and the state is paying my fees. So the capital sex bat charge is 794.011, which is intercourse or penetration of the vagina, oral cavity, or anus. So any penetration is considered capital sexual battery penetration. Lewd and lascivious would be inappropriate touching or fondling, which is more the rule than the exception. At any rate, in Florida, when you're arrested on this, it's a life felony. You're toast. It's absolute lights out time. Jeb Bush signed this back in 2007 before he left the governor's mansion. Life without parole. I have two clients of mine in prison right now in Florida that I know are factually innocent, but are facing life. And I know they're factually innocent. But of course, I'm just a little piece of the puzzle. As an expert, I feed information to the attorney. The litigator, the attorney, really controls the case. I don't. So even if I'm working as consulting expert, I'm helping with strategy, case law, emotions, even questions on direct and cross and redirect and recross in a hearing or trial. It's the lawyer who has ex parte conversations with the client. The jury's going to believe Tong or they're going to believe the kid. Kids don't lie about sexual abuse, must be believed and protected at all costs. That's a really what if. So you're taking a real risk with Tong because the jury may not believe him. He may not be more credible than the kid. And of course, under Rule 704, it's up to the jury to determine credibility and the ultimate issue, whether you did this or not. So whether you're accused of physical abuse, sexual abuse, psychological abuse, parental alienation, emotional, mental, psychological child abuse, Munchausen by proxy, whatever. Rule 704, the ultimate issue in a criminal matter is decided by the jury, and a civil matter by the judge. So in these he said, she said cases, Paul Waldmiller cases, domestic violence allegations, marriage scam allegations where VAWA is used as a tool weapon, its credibility, and if Paul did have an evidentiary trial, it would be his word against his ex-wife's word. That's a real slippery slope. And yet most lawyers don't think they need experts because they don't want the money spent, or they don't want their egos put in question, the lawyers. They don't need the help. They can do this on their own. They can impeach the witnesses on their own. They don't need any help. So the case that reinforces 90.80323, the 23rd exception of the hearsay rule in Florida, is State v. Townsend, Townsend. That's a 1994 case, and that's the case that's used in basically all hearsay cases, whether it's juvenile court, dependency court, criminal court. That case is always cited because there has to be an indicia of reliability and an inherent degree of trustworthiness that accompanies the hearsay. So as an expert, I'm looking for what's called a trigger. What could have triggered that child to make an allegation where you might as lay people think it's coaching, okay, where the child was brainwashed or poisoned or programmed or indoctrinated to say what happened. Most of these cases are not coaching. Okay, it's not what you know, it's not what you think you know, it's what you can prove in a court of law. And I'm taking that off of the law-abiding citizen with Jamie Foxx and Gerard Butler, but it's a point, because the reality is here, you have to prove your case, and in family court and dependency court, like Raquel said, it's a preponderance of evidence, 51%. So 51 to 49, you're more guilty than less guilty, or you're less guilty than more guilty. It's a very slippery slope. It's a very gray area. Judges oftentimes err on the side of caution. They'll err on the side of the children. Why is that? Well, because they haven't seen the data that I have, and I've been doing this now for 30 years. It was 30 years ago this year I got arrested for allegedly raping my daughter in 1985 when I got started. I started doing this professionally 10 years later in 95. Most judges haven't seen the data on what happens to the non-abused child who's treated as if she is a true victim. Okay, so we suffer from what's called confirmatory bias. We have a preconceived notion that this happened because it's such a heinous, reprehensible allegation, and we're going to treat it as if, in fact, it did happen. Okay, without examining alternative hypotheses or explanations for why the kid is saying what she's saying or what he's saying. So this is called source monitoring. So source monitoring is a very, very, very important concept in any case, whether it's a dependency case, whether it's a criminal case, even a family law case. Is everybody looking at other alternative explanations and hypotheses for what's going on? Has there been an independent, objective investigation or examination of the origin or source of the alleged trauma according to the child's memory? So instead of the mantra, children don't lie, must be believed or protected at all costs, that shouldn't be the way we look at these cases. We should actually challenge the child when the child says to mommy, well, my stepdaddy Johnny did this to me, or my brother's friend did this to me. That's going to be put in question. When you don't question the kid, then the kid's not doing source monitoring. That's when it all breaks down, okay? That's when it all breaks down, and you're going to get a rubber stamp, or you're going to get a validation of the kid's allegation. It's going to be confirmed by the government. They don't want to investigate Tom, Dick, and Harry. If Dean Tong is a suspect, that's all they want to look at is Dean Tong. They don't want to look at anybody else. They don't have time for that. They don't have the resources for that. They don't want to go there. So in my practice, I usually require my clients to go through psychosexual testing to prove a negative or prove their innocence. Well, I do that because there's a science behind that. So if you are interested in prepubescent little girls or boys, chances are you did what you're accused of doing, and vice versa. Are you going to get this advice from your lawyer? No. Lawyers are lawyers. They don't get this stuff in law school. Those that have heard of my name may have been to my website or seen me on Dr. Phil or whatever. The reality is, unless they're Desmothenes Lorandos, whose website is psychlaw.net, he's a JD PhD, he's a psychologist and a lawyer. Unless they are Desmothenes Lorandos, I call him the Greek god. He's licensed to practice law in Michigan, New York, DC, and California. You don't need me if you can afford him. Good luck on affording him. 50 to 100K. Most lawyers are not him, okay? Most lawyers don't know what they're doing. They're going to get that retainer check. They're going to put their best foot forward. They might fight for you. They may file a couple of motions, go to a hearing. They might even hire an expert just to appease you and placate you. The reality is, it's usually a dead end. In law, in court, you get one shot. You get one bite the legal apple, and by God, if you don't do it right the first time, it's legal suicide. The law doesn't wait. So I challenge attorneys. It's what I do. And basically, I'm not here to be friends with lawyers. You know, I mean, my website is going to keep getting clicked on. I'm still going to get calls. I'm going to get emails. I'm going to get text messages. And, you know, the bottom line is the client has to induce the marriage between Mr. Tong and the attorney. That's not for me to do, because if I get into an argument with the lawyer's going to file a motion to withdraw as counsel of record. You're going to be left pro se. Okay? Not a good way to go. So basically, the lawyer calls the expert, not the other way around. I have worked cases from all 50 states. My website is approaching 900,000 hits. That's the population of a major U.S. city. That should raise so many eyebrows in Washington, D.C. My website is approaching 1 million hits that's surreal. How could that happen? So getting back to the source monitoring on the children, I'll give you a case in point on suggestibility. And you know, we talk about suggestibility and what is suggestibility. So suggestibility is the susceptibility or vulnerability of putting words and thoughts and ideas into a child's mind. Okay, children are like sponges. They're very susceptible. They can talk about the Tooth Fairy, Santa Claus, Peter Pan, and the Easter Bunny. They can talk about how Daddy touched me in bad places. You give them a toy, a doll, a puppet, a drawing, even easier, much more so. So I had a case in 2000 from Daytona Beach, and the guy was charged with 794-011 capital sex bat, facing 25 years to life in prison. Now it's life without parole. And the little girl, 4 years old, said, Amber said her daddy put his pee-pee on her pee-pee. So of course he was arrested because the government gleaned it was sexual on sexual contact. He put his pee-pee on her pee-pee. But what the little girl meant was that Daddy urinated on her urine in the commode she forgot to flush. A linguistic error that nobody with half an education would know. So we called in Dr. Ann Graffam Walker, who's one of the top forensic linguists in the country, to look at that case, and she actually got to sit down with that girl. And that's unusual because in most cases the defense will not have access to the kid. The state will file a motion for protective order, and the state will not have access to the child. You can't get that kid polygraphed, you can't get that kid psych evaled, you can't get that kid interviewed by your expert. So it's all by the state. And in child abuse cases where there's no forensic evidence or proof, whether it's a physical abuse case with injuries, radiographic findings, or physician's opinions that there are broken bones or whatever. What are we talking about here? We're talking about memory. We're talking about memory. When a guy's arrested, he's going to go to trial maybe 18 months or 24 months later. So we're talking about memory. We're talking about encoding, storing, retrieving, and reporting. That's what memory is. And what better than to reinforce the child's memory than activate the kid's recognition memory and eradicate the autobiographical free recall memory. So when we activate recognition memory through dolls, puppets, drawings, or in an older child, maybe a teeny bopper, cognitive behavioral therapy, or what's called EMDR, eye movement desensitization reprocessing, which is a newer methodology they're using. Now the kid's focused at a high rate. This is what happened, and this is who did it. This is the scenario, and this is the perpetrator. There's no other possible suspect. There's no other possible scenario for how this happened. So in Florida, in a criminal case under State v. Roberson, R-O-B-E-R-S-O-N, the lawyer can't get me the clinical session progress notes of the child's therapist. It's not allowed. So there's an inherent therapist-patient-client privilege in Florida in a criminal case. In a family law case, I can get those notes when your rights as a parent are in jeopardy, but not in a criminal case. Likewise, in a criminal case in Florida, State v. Karelas, K-A-R-E-L-A-S, I'm not allowed to opine at a taint hearing, a Daubert hearing, pretrial hearing, on whether I think the child's information was tainted or contaminated or adulterated or was a product of reliability and validity. So those two cases are out of the 5th DCA in Daytona Beach, what we call the PCA court in Florida. For anybody who's familiar with appellate work in this state, the 5th DCA is notorious for coming back with PCAs, per curiam affirmed, which means you lose your appeal. You lose. It's a terrible appellate court for appellants falsely accused of abuse and the like in this state. So basically what they're telling me in Florida is that a judge is not going to rule just because Mr. Tong thinks the methodology was improper and the child's information may be tainted. We will see Mr. Tong at jury trial. That's what the judge is saying. I'm not going to make a ruling on that. I'm going to let the jury decide that. That's, again, Rule 704, the ultimate issue, credibility. I'm not going to go there. The jury's going to decide that. In Florida, the only time you get a 12-man jury is murder one. Murder one. Every time else, you're going to get a 6-man jury. If I am selected as a testimonial expert or I'm giving an opinion to a reasonable degree of psychological scientific certainty on the witness stand, I cannot help the lawyer select the jury. I can't do both. So I can't sit there on day one where the prosecution and the defense are selecting the jury and say, okay, counsel, I don't want that guy. I mean, that guy watches Oprah Winfrey. That lady watches Oprah Winfrey. She was abused as a child. She's a feminist. I don't want that person on our client's jury. Are you kidding me? It's legal suicide. Can't do it because I've already been selected as a testimonial expert. So you're getting me a one snapshot in time. Once I pass voir dire, I'm going to be given an opinion on the witness stand. Jury's on my left, prosecutors right in front of me in the center, judges to my right. I'm there for 2 to 4 hours at a time. If I come in as a consulting expert, I can help the lawyer all the way from jury selection through the case in chief to the jury verdict. And I did that in a case in Dallas, Texas back in '07, right before the recession hit. And that was an incredible case where the woman who was 26 accused my client of raping her when she was 12, 14 years earlier. He was a stepfather, and during the act of molest, and this was no lie, when she testified, she said, I saw aliens in biochemical suits and UFOs. I helped pick that jury. There were 12 men, 10 men and 2 women in that jury pool box. And I was looking at the 24 eyeballs in the jury when she was stating what she said, what I just told you. And I mean, 6 of 12, the eyebrows clearly were raised off the forehead. But guess what? They came back 2 days later and convicted my guy. And the judge was even floored. He said, you know, the evidence just doesn't the evidence doesn't wash here, but I have to respect the American jury. So, sir, you are guilty, but I'm going to give you the least amount of time. So he was facing 2 to 20 years. He got 2 years. He got 2 years. And he went to Colorado City, Texas, in prison. Wrote to me from prison. And of course, that was back in 07, so he's been out now since 09. So these little kids are sticks of dynamite. They are absolute sticks of dynamite. They are ticking time bombs. These therapists, I have so many articles on first do no harm. They start treating these kids before there's been a legal adjudication of guilt. There are a dime a dozen, these master's level therapists in all 50 states. A dime a dozen. There are some good therapists out there. There are some good cops. There are good social workers. But for the most part, there's extreme naivete. They haven't read my work. They haven't read Dr. Stephen Ceci's work, C-E-C-I. Jeopardy in the Courtroom is the Bible. They haven't seen the studies back from 20 years ago. Studies like Monster in a Box, Mousetrap, Genital Conditioning, Simon Says, Mr. Science. All these studies. Some of these studies aired on Dateline in 2020. And over half the kids who were interviewed were mistaken when they were talking about sexual touches with adult men. In fact, one little girl said the pediatrician hammered a stick in her vagina to the interviewer. That factually never happened, clearly never happened. I had a case from Tennessee. I testified as an expert 4 months ago in December. And the little girl said he molested her on the ceiling. My client. So I told the judge, I said, Judge, that clearly did not happen. Just didn't happen. And she said, I agree with you. So we won that case. A lot of mistakes. There's a clear difference, however, between coaching, false allegations, and unfounded. Okay, so coaching is a malicious act. It's an act in bad faith. It's premeditated. As I stated earlier, it's not what you know. It's not what you think you know. It's what you can prove in court. So in order to prove coaching, unless the parent says to you, yeah, I picked up the phone. Yeah, I called 1-800-96-ABUSE. Yeah, I want to do the fatherectomy. I want to eviscerate him from the life of my kid and vice versa. Yeah, I got him. I know how to get him. I'm going to use the Dean Tong method, the ultimate weapon. Divorce is atomic bomb, the nuclear weapon. And I know how to get him. No woman's going to admit that. What woman's going to admit that? They're going to go to their grave with this. Likewise, you're not going to have this on video, are you? So how do you prove coaching? I have to see the forensic interview. If I see the forensic interview and the child says on the interview, my mommy told me to say bad things about my daddy, that's coaching. That is coaching. Under Florida Statute 39.205, subsection 9, that's a felony. You could go to prison for 5 years in Florida. I'm actually the guy who helped push that along back in '98 with former Senator Jim Huggerett right here in Tampa. Has there been a successful case on that, prosecution-wise? To my knowledge, I think one. It's on the books, probably to appease me. But the reality is, it's a slap on the wrist. In most states, by the way, it is a misdemeanor. I think we're one of 4 or 5 states that make it a felony. So the national statistics are 2 to 9%. 2 to 9% are false allegations with a median of 5, which means if there's if 2/3 of these cases are errors or mistakes, wow, we've got a lot of mistakes being made. We've got upwards of 60% errors being committed by the system in these cases. And when you're talking high conflict divorce, custody, and parenting time disputes, it's probably closer to 80%. This is to take nothing away of kids who in fact are being abused, and women who are being abused. So just to mention VAWA real quick, like Paul said in his talk, the Violence Against Women Act, which is 18 U.S.C. 2265, was authored by our current Vice President Joe Biden back in '94. It was part of the National Crime Act, and again, a well-meaning, well-intended law, just like CAPTA. On the child abuse end of things, the Child Abuse Prevention and Treatment Act of 1974, the Mondale Act, also known as. Well-meaning, well-intentioned. You can make anonymous phone call allegations to hotline numbers. You can have total immunity. You can't sue the state in federal court for money because of the 11th Amendment, but you can sue the DCF individuals. You can sue the caseworkers in their individual or personal capacity. You just cannot use the word official. If you use the word official in your complaint, it's implied you're suing the state, and you can't do that. So you have to use the word personal or individual capacity. And you can sue the individual people. You just cannot sue the state of Florida, DCF, a state agency, which is operated and run by the governor, Scott, for money in federal court. And to piggyback Glenn's talk, I totally agree with Glenn that you're going to get a stronger and quicker equity of law in court, in federal court, than you will state court. State court, the politics cuts like a knife. Good luck on that one. The Florida statute is 768.28, our tort statute. The statute that I like to use, that I get most lawyers to do, like I have a case ongoing in Alabama, is 42 U.S.C. 1983. So remember that one, 42 U.S.C. 1983. That's our negligence code statute. So I have two cases. Just to mention VAWA again. So on the VAWA, under Florida's ex parte domestic violence injunction, it's 741.30. Okay, that's the statute, 741.30. It says it right on the front form. And basically, usually filed by a woman. I'm not trying to be gender biased here, but this is usually how it comes down. So the woman is going to file this injunction against you. She's going to make an affidavit. And in that affidavit are going to be allegations. And all she has to say is a statement of fear, threatened bodily harm. That's it. You know, that you kicked her, you scratched her, you pushed her, you punched her, you bit her, whatever. No proof, no evidence. No fault. No proof, no evidence. And a judge will sign off on that in a New York minute. And you're going to be served, the respondent, the man, you'll be served with a copy of the same, and you'll have your 2-week hearing. You will have your day in court. Now, do you think you have enough time to prove a negative in your innocence in 2 weeks? Good luck on that one. Because you don't. You won't. I don't care who your lawyer is. Trying to impeach your accuser in 2 weeks, that's the David Copperfield Act. So chances are the judge is going to extend out that DVI. And also, I might add, there's a guy in Flagler County, he hit me up on Facebook, and he's been served with what's called an SVI, sexual violence injunction. So if you don't think you can be accused of sexual acts in a DVI, think again in Florida, because you can. It's now called an SVI, same standard of proof, preponderance of evidence, and a judge will sign off on that sucker. So you're left presumed guilty. You're left presumed guilty and having to prove your innocence and proving a negative. And of course, if you go to my website, abuse-excuse.com, my common theme strategy is to impeach the allegations, whether it's a child or the adult complaining witness, and then of course go through testing. I'm a very firm advocate of testing. So the two cases I have, I want to talk about briefly. Excuse me. One from Alabama. It's a current lawsuit of mine. It's in litigation. It's been going on since 2012, and we're starting to be fed numbers. In other words, the defendants are starting to mediate with us and throw numbers our way. They clearly know we're going to win. It's just a matter of whether they're going to pay my client the amount of money he wants. So this lawsuit has named a DCF in Alabama. It's called DHR, a DHR caseworker, who's represented by the AG's office, Attorney General's office. So of course Governor Bentley, who's the governor of Alabama, gets all the pleadings and court orders in this lawsuit case. because he oversees the DHR, just like Governor Scott oversees our DCF here in Florida. Do they know Mr. Tong's involved? Absolutely. I showed up at depositions last July of that same DHR worker and a therapist and the forensic interviewer. Did the lawyer use most of my questions? Absolutely, because the client made him do so. Client told the lawyer, there's only one person that's irreplaceable in this case, counselor, and it's not you. So that lawyer almost wound up with a broken tibia at the end of the 8 hour of depositions that day because I kicked him like 6 times underneath the table. I said, counsel, we're going to get on the show on the road here because I don't see my questions being asked. And I'm not here to swap spit with you. I'm not here to make friends with you. I have a job to do, and ultimately, you're going to do your job, which means you're going to ask my questions. So the intersection of science and the law is necessary here, absolutely necessary. And most lawyers don't get that. Most lawyers don't want to get that. I make them get that. Proper science applied to proper law in court. Again, unless you're Desmothenes Lorandos, you're not going to have the requisite knowledge in social science, behavioral science, mental health, or psychology. Very, very necessary in these cases. Okay? That includes DCF law. I mean, how many lawyers do I have to tell to subpoena the policy and training manual, the standard operating procedure manual? Oh, I didn't think about that. I've never seen that before. Okay. Would it surprise you if I told you it's 1,000 pages? Yeah, it would, because I've never seen it. Would it surprise you if I told you that it's necessary so we can compare and contrast what the DCF did in this case to what their published guidelines require them to do? Oh, that's a good point. So, again, my work is a slippery slope because I teeter between giving expert testimony and actually providing strategy. I'm usually not allowed to do both because it can color my objectivity on the stand. And most adverse counsel won't let me do both. They'll object. Judge, he can't possibly give an opinion as an expert and also be directing the show here. And the judge will look at our lawyer and say, counsel, do you have any cases on point where Mr. Tong can help you try your case and give an opinion on the stand? Well, recently I was allowed to do that in Tennessee. Our lawyer was that good. If you want to go to her website, Carnes, K-A-R-N-E-S, CarnesLegalServices.com, Lannis Carnes. She does a lot of pro hoc vice work for me, which means she can work out of state. Even though she's only licensed in Tennessee and Virginia, she can litigate it in any state. And she is a really Southern belle, Southern drawl attorney, but very competent and a shark, a little 5'2" shark. So to get back to my Alabama lawsuit, my client was charged with raping his daughter in 2009 when she was 2 and 9 months. 2 and 9 months. So the age at which you're supposed to be able to distinguish fact from fantasy is 3. 3. So anything under 3 should be cognitively impossible. It should be moot. And the little girl said, Dada hurt me, Dada made me sad. So when the little girl said, Dada hurt me, Dada made me sad, and rubbed 2 little dolls together, the therapist gleaned that that was sexual behavior and picked up the telephone and turned my guy in. And of course, once the government got involved, I probably don't have to tell you what happened. So they abdicated to the therapist's opinion. They put my guy on the child abuse registry list in Alabama. Interestingly enough, they didn't know who they screwed with. My client was a very prominent individual in Alabama. The father's a physician, cousins works for the Alabama media, and his brother's a lawyer. So we got by motion to dismiss. They have just filed motion for summary judgment. We are in the process of responding to the same. I feel very confident we will get past motions for summary judgment. They're already calling our lawyers, asking for how much money my guy wants, and he wants no less than $200,000 per defendant, so the 7 defendants, which would make it $1.4 million. That would be the highest dollar amount, to my knowledge, in Alabama history on a case of this nature. The other case I have is the reverse case. It's a mother in Canada. She's on Facebook. She hired me when the case was in California, and she was accused of. Actually, let me rephrase that. The father hired me in June of 2013 for allegedly raping his daughter, anal sodomy, and I wrote an email that quasi-vindicated him to the lawyers, but the mother hit me up on Facebook, and the father's camp sent me 300 pages of discovery. The mother sent me 3,000. So I did the mother's side pro bono because the father had already paid me, and then I wrote a declaration on the record for the mother that I think the court got it wrong and the kid's been raped. The judge got so ticked at me, he was going to hold me in contempt. He filed an order to show cause against me. He was going to have me picked up in Florida and flown back to California incarcerated. So I had to hire a lawyer to get myself out of that. The reality is I challenged the court, and the court didn't like that. So that little girl had 3 anal fissures, and her testimony, her statements appear credible to me. But she's living with strangers right now. It's ironic because the father was awarded custody, but the father is not even in the United States. So here's a guy who got an award of custody of his daughter, and he's not even here to enjoy that award. Amazing. So I think Chris said I'm running on short time here. Pretty much sums it up. Anybody have any questions, concerns, comments? If not, thank you.
Dean, I do have one question. You said that DCF won't provide that their manual of their procedures. How can they withhold that? Don't they have open records law that they have to abide by?
Yeah, I mean, there's the Freedom of Information Act. There's the Public Records Act. You can file a request for production, a motion to compel production. The lawyer can. But if you file the motion to compel, you're asking a court to make an order. A motion is asking a court to make an order, okay? So if it gets to that point, you're probably going to have a hearing on the matter because there's a motion filed. The judge is going to order a hearing, and it's 90.403, Florida statute 90.403. Does your right to due process to be able to see everything being used against you, does that outweigh the prejudicial effect of the government trying to insulate its case and remain confidential? Because they have confidentiality statutes. And that's what they're going to stick by, is their confidentiality statutes. They do it all the time. And under 90.403 in the 14th Amendment to the Constitution, your right to due process, does your right to due process outweigh that right to confidentiality?
I have a question. During the deposition, when you asked the attorney to ask those questions, that was directly to the attorney, or did you instruct the client to ask the attorney?
No, the lawyer and I had been doing a lot of cases together, and he was affronted by me that day during our coffee break. I said, look, we've been at this an hour and a half. You've asked one of my questions. I've got 85 written for this deponent. So the client happened to be at the coffee break and looked at it and says, Kevin, I'm not asking you, I'm telling you. Yes, sir.
There was yet another article, I think it was in the Tribune the last day or two, about a woman, a teacher or counselor being accused of some type of sexual relationship with underage children. It seems to be an increasing trend.
Here in Tampa?
Just nationally, but
okay.
It seems to have started here in Tampa with the Lefebvre.
Yeah. You're talking about female teachers and kids
right.
that
are we seeing any kind of equivalency in the case? What's happening in the cases and the sentencing and yet, or what's kind of that trend looking like?
Well, it's I don't know what the stats are on that. It's a growing gender issue to me. I mean, you read about these female teachers that are having affairs with teenage boys. It's like Mary Kay Letourneau, the case that made national attention from Washington State 20 years ago. She went to prison, right? And I think she even got impregnated by that kid.
Yeah, twice.
So Deborah LaFave, she was so hot and good looking, she couldn't go to jail because, there would be issues with the guards. So either lesbianism or heterosexuality, whatever.
She didn't get 25 years or anything like that.
No, she got a slap in the wrist. She got probation. So I mean, do you go to Chattahoochee, which is our loony bin, or do you go to the joint, where there's going to be gangs, shanks, rapists, and murderers? And most prisons are run by gangs now. You go in as a baby raper, and you better have protection, because you don't have to worry about the charge you're in for, because the guards are going to leak that jacket of yours to the other inmates, and one of the shot callers is going to hit you in population. And I tell all my clients that you're not going to get this advice from your lawyer. I'm telling you this. I'm giving you general practical advice of what you're facing. So you can either take your plea bargain, okay, because most of these cases are plea bargain criminally, or you can go to Tong trial. And I understand this is a what if. There's always a what if in life. It's all about risk reward. That's what life is all about, risk reward. And the easy way for the lawyer is you just paid this lawyer $25,000 8 months ago. Now he wants to plea bargain you. Think about that. Okay, with me, maybe my last name starts with a T for a reason, but with me, you're going to go to trial. But I have no control over that. It's just between you and your lawyer. I have to work with your lawyer to be able to work as a team. This is three musketeers, and if there's dissension within the team, the lawyer is going to have an ex parte conversation with the client, and I'm not going to be privy to that conversation, and it's game, set, match. You're done. So, the lawyer can intimidate you and scare you into prison, and probably will do so. But remember this, in my caseload, which are 95% child sex cases, it's worse than murder, because you're going to face Megan's Law of sex offender registration, and that's for the rest of your life. Okay, so you're going to have that scarlet letter emblazoned upon your name, and you're going to walk with that to your grave, unless you clear your name. So, with my caseload, it's much different than a finding of fact or conclusion of law by a family court judge or a juvenile dependency court judge, or even a verdict by a jury. With my caseload, there's that sex offender registration mark. Most prosecutors in these cases in Florida are women. Again, I don't want to get down the gender road, but I know, because I work these cases for a living, most are women. And most of these women, while they're members of the bar and officers of the court, they got in this for a reason. Why? Because maybe they were abused as children, or they thought they were. Child savers, true believers, validators. That's what's going on here. Okay, so instead of questioning the kids' statements, we're going to rubber stamp that kid's statements, and we're going to nail the accused. Welcome to my world.